All right, this is our final case for this morning and for the call. It is Keith Bronner versus the City of Detroit. It is a 15-minute mini oral argument on the application. Mr. Ramey, you can reserve some of those minutes for rebuttal. We would ask you to keep track of that on your own, and you may proceed.
Thank you, Your Honor. Charles Ramey, Deputy Corp Counsel for the City of Detroit. I would like to reserve 5 minutes for rebuttal. In this case, the City of Detroit was acting in two critically important municipal capacities. The city operates what is by far the largest public transportation system in the state of Michigan, and the city self-insures its no-fault liabilities. So the city paid Mr. Bronner's no-fault benefits when he was injured on a city bus that was struck by a negligent GFL, a garbage truck driver. The city also, of course, operates a garbage collection system and contracts with GFL for garbage collection services. The contract has a broad indemnification provision where the city is entitled to indemnification to the extent it suffers a monetary loss as a result of GFL's negligence. And all city vendors have such indemnity contracts, and it actually would be municipal malpractice not to require that indemnification. The Court of Appeals, in our view, clearly erred in striking down the indemnity contract. This court's decisions provide the utmost protection for the GFL city contract. And under this court's decisions, the contract must be enforced unless it actually conflicts with the No-Fault Act. But the No-Fault Act is silent on contractual indemnity, and there is no conflict between the contract and the act whatsoever. The city, of course, paid Mr. Bronner's benefits, and the city agrees that it was and would be in all similar cases the primary and sole insurer of a bus passenger who is injured on a bus under the No-Fault Act, to the extent the No-Fault Act so provides. Separately, the city is entitled to enforce its contractual indemnity against a vendor that negligently caused the losses. The Court of Appeals rejected the city indemnity claim on the theory that there was nothing in the No-Fault Act that expressly supported the contractual indemnity claim. But that was exactly backwards and contrary to every relevant decision of this court. It was also contrary to the fundamental right of freedom of contract. And under that fundamental right, the No-Fault Act would have to affirmatively provide something that prevented enforcement of that contract. If the No-Fault Act is silent, as it is, and if there's no conflict, which is the case, the city is entitled to enforce its contractual indemnity.
I'm going to interrupt you here, Mr. Ramey, and let me see what questions folks have, and if they don't have any, you can go back to your presentation. Justice Viviano.
No questions. Thank you, counsel.
Justice Bernstein.
Good morning, counsel. I just have a simple question. What would the significance be if the court were not to act in this case?
Well, I think it would set a terrible precedent, because the city, obviously, the taxpayers of the city of Detroit should not be responsible when the city has to pay damages as the result of the negligence of a vendor. And as I said before, we have indemnity provisions in virtually all vendor contracts. This one obviously was a garbage truck case, but there are many vendors that drive many different kinds of vehicles, and this case could recur in the future. And it's also, I think, why this case is so wrong is that the city also has a constitutional home rule right to protect its taxpayers from the negligence of vendors. So I think it's a very important case for the city of Detroit and for all municipalities that want to ensure that their taxpayers are protected from the negligence of vendors. I hope that answers your
Thank you,
question.
Council. Yes, it does.
Justice Clement,
No questions.
Justice Kavanaugh,
No questions for me.
Justice Welch,
No questions.
Justice Zara.
No questions, thank you.
Mr. Ramey, you may continue or you may reserve time, up to you. You have 9 minutes and 46 seconds left, so you have plenty.
All right, I'm going to make one more point and then stop. I want to refer now, make the point, the fact that the No Fault Act is a, quote, comprehensive legislative scheme, which GFL mentions in its brief, makes no difference whatsoever in this case. This court's decisions in Cruz and Universal Underwriters upheld contracts in the context of the No Fault Act, even though they had no statutory support in the No Fault Act. The court upheld those precisely because there was no conflict, just as there is no conflict here. And in the Zahn case, this court upheld a contractual indemnity contract in the context of the Workers' Compensation Act, which obviously is a comprehensive legislative scheme. And Zahn, even though it dealt with workers' compensation, in many ways is extremely and very directly on point here. In Zahn, the employer argued it could not be responsible for a contractual indemnity claim for injuries to the employee because workers' compensation was an exclusive remedy statute. GFL makes exactly the same claim here, arguing it cannot be subject to contractual indemnity because the No Fault Act is an exclusive remedy scheme. This court rejected that argument in Zahn and should reject it in this case. Thank you.
You may reserve your time. Mr. Caffrey.
Good morning, Your Honors. May it please the court, Anthony Caffrey on behalf of GFL. I would just like to begin with the statement that, the legislature has not just enacted a comprehensive statutory scheme, they wiped the slate clean and created something called first party benefits. If we were to have a time machine and go back 50, 100 years and say, somebody owes first party benefits, nobody would know what you're talking about because it's entirely created by statute. And when they created this scheme, they created the rule book, and that's prior Supreme Court, this court's decision that this is the rule book. And under those rules, an insurer is required to pay first party benefits. It's one of their rights and obligations. The legislature set out methods, and the only methods upon which an insurer can recoup or recover or reimburse or obtain payment for what it has already paid. Okay, there's provision for indemnification under the Michigan Catastrophic Claims Association. There's provisions for reimbursement from a tort recovery. There's provisions for reimbursement from another insurer. Under general principles of statutory construction, where the legislature in this comprehensive scheme has set out multiple avenues for an insurer to recoup those first party benefits, those are the avenues. That's expressio unius est exclusio alteris, which I haven't memorized, so I had to look at my notes for, but it's a well-established principle. We cited authority that's one of the most important principles of statutory construction. What's really happening here, I mean, we've lost sight a little bit of the forest from the trees here. This is the No Fault Act. The legislature, in its wisdom, subject to criticism, but in its wisdom, decided that we're going to balance the interests of everyone. Injured parties, tortfeasors, insurance companies, and they created this system. There's trade-offs, and one of the trade-offs for insurers is that they are required to pay certain benefits. And that's it. That is part of the trade-off. It's the No Fault Act. The insurers are not liable because they're at fault. They're liable as a matter of law. And the legislature also created a provision where entities such as the city of Detroit, and I think there's about 50 or so other entities, can self-insure. But once they do that, they're taking off their hat as an entity, whether it's one of the governmental entities or a diocese or a corporation or a university, and now they become an insurer with the same rights and obligations of an insurer. That hat is taken off and it can't be put back on, or self-insurers will have different rights and obligations than insurers.
Let me interrupt you, Mr. Caffrey, and just see what questions folks have, and then we can get back to you if there are none.
Okay.
Justice Viviano,
No questions.
Justice Clement. I'm sorry, Justice Bernstein. I didn't mean to skip you. Justice Bernstein.
No problem. And at this point, I have no questions. Thanks, though.
Okay, Justice Clement.
No questions.
Justice Kavanaugh.
I just have one. I wanted to follow up a statement that you made, Mr. Caffrey, of that when the no fault statute was enacted, we sort of wiped the slate clean and here's the rule book. But there are decisions from this court as recently as last term that speak to what's not in this rule book and how we're supposed to decide those, right? The continued viability of common law defenses, the Bozzi case, the Mimic case, Cruz, for example. So why are we not squarely in that analysis under Cruz as the city maintains?
Well, when you're talking about first party benefits, this is a mandatory coverage for automobile driving. And, as an example, in the Nealon case, it involves collision damages. That's something that is not required for anyone to have. In that circumstance, you are in the common law. But the legislature didn't say first party benefits coverage is going to be optional. They made it mandatory.
But let's take that apart. The city is saying they owe the benefit. They owe the benefit. So we're not talking about the mandatory benefit. We're talking about their ability to contract for, and I think, as you point out, a very rare circumstance where you not only have a self-insured, but it's a self-insured who's likely to have some kind of a contractual relationship with a potentially negligent at-fault party. Maybe it's rare, maybe it's not. But we're not talking about the mandatory benefit. We're talking about their ability to, we have to pay it, but what does why are we not in Cruz to figure out how the No Fault Act affects, if at all, their contractual claim?
Because the legislature spoke as to the methods upon which insurers can recoup, however they're going to recoup those benefits. And they created specific methods, as the Court of Appeals noted, as to when they can do that, how they can do that. And we can't just assume because the legislature did not expressly state something that is the end conclusion, because that runs contrary to basic statutory construction. If you think about it on a more logical sense, if the legislature had wanted to provide for fault-based contractual indemnification, they might have said, well, you know what? You can get that, but here's the rules. You have to set it out expressly in a contract. You can't rely on just a general indemnification clause like the city is doing here and is foreshadowed that they plan to do in the future. Secondly, the No Fault Act, one of the purposes was to decrease litigation. And here we are, 2 years after plaintiff finally got their money, we're before this court. This is the type of litigation you get. And this is just the beginning. If it's ruled that self-insurers can do this, there's 50 plus other self-insurers that are going to start looking at when they pay first party benefits. Was that person who caused the accident or contributed to it, were they an employee of one of our vendors? So you're going to see that type of explosion of litigation, but you're really going to be opening the door to insurers doing that also. If a self-insurer has the same rights and obligations of an insurer, and a self-insurer can do this, an insurer can do this. And, we pointed out in our brief one example of insurers that are insuring both vehicles in an accident or multiple vehicles. And you've probably seen that in practice. I've seen it. There's cases that are published out there in other states where that happens. They can craft a way to recoup those first party benefits from their own insureds.
But whether they're self-insured or an insurance company, don't they do that? I mean, they've paid the benefit, and then, doesn't your Allstate or Farm Bureau or whatever have ways to figure out how to accommodate that loss within them? And this is like the city of Detroit, the same thing. We have, the city of Detroit is one pot of money where, this is how we're doing it. As long as it's not affecting their statutory obligation to pay the first party benefit, Why is it a concern of the No Fault Act at all?
It is a concern because the No Fault Act has a balance between the premiums coming in and the benefits going out. You match that up as let's say as the MCCA gets greater claims, and that is a source of indemnification that the city could avail itself of. As those claims go up, because the premiums go up, and that's how you get this balancing between. It's a unique, inclusive system. Collision is outside of that. You're not going to have runaway collision damages, but you very well may have runaway first-party benefits damages.
Okay,
And I
thank
would
you.
note that this is. Let me also say one thing: that
Mhm.
if insurers are allowed to do this, they can rely on common law indemnification because they will be a party that's liable despite not being at fault. They will be able to pursue fault-based common law indemnification. And the argument's going to be, well, the legislature didn't preclude it, but that is contrary to both the letter and the spirit, because this is how you go after at-fault parties, and they didn't say go after them this way. It's going to be contrary to one of the intents, which was to reduce litigation. And again, here we are, multiple years after this accident, we're arguing this issue, and it's going to open the doors. And I think this court should decline to grant leave, but perhaps invite the legislature to take a look at it, because if it's going to be allowed, it should be done in a carefully crafted manner that considers all the competing policy decisions. And that's what the Court of Appeals said. If we're wrong, legislature, take a look at that.
Thank
We
you.
move on to Justice Welch.
Thank you.
No questions. Thank you.
Justice Zara.
No questions, thank you.
Counsel, I want to sort of go back to Justice Kavanaugh's question. It feels like you're making this slippery slope argument that doesn't add up to me, because I feel like if that type of insurance policy was where insurers went, it would be sort of self-defeating because the risk would still be borne by the insured. So I'm not sure why anybody would buy that policy. But back to the purposes of the No Fault Act, it seems to me it's important to your argument that we agree with you that the tamping down litigation is an important purpose, and rather than just making sure an injured party is compensated and compensated quickly. The city has not said. The city is not claiming that it doesn't have to pay the injured party's costs. So tell me how to think about those they feel like competing purposes. If you're right that tamping down litigation is what the purpose of the No Fault Act is, I can see how that favors the outcome you'd like to see here. But I'm not sure that is the most important purpose. How do I think about that?
In this very litigation alone, the plaintiff filed their lawsuit in 2017. Many months were invested in trying to argue that my client was first in priority. Although that's clear under this court's authority that that's not the case, time was spent on that. Delay recovery for a plaintiff. Litigation isn't just a new lawsuit. It's also the separate arguments that can be raised, the lengthy delays. And again, plaintiff has their money, and then here we are. And it's one lawsuit this time. Next time it's going to be two lawsuits, perhaps. It delays recovery for plaintiffs also. And the whole purpose of the No Fault Act was to get these first party benefits paid by an entity that's part of the system, okay, who's charging premiums. And if an entity decides to self-insure, it's only because it's going to be more economically beneficial than paying the premium. In other words, they're saving money by doing that. So they're coming within the system still by not paying premium. There's still this set universe of potential premiums and benefits that are being paid out. The legislature looked at the concern of what if there's a need for indemnification, and they provided indemnification by the MCCA. They provided for reimbursement from another insurer. They provided for recoupment from the insured or the injured party in that case. And they provided for circumstances where you can have a tort recovery. They have spoken. And it's not for us to go back and question that and say that they haven't spoken.
But they've occupied the field and spoken about tort recovery, but it doesn't seem like the statute says anything about contractual recovery. I mean, if the indemnification provision is enforceable, isn't the takeaway that your client and any other insurance company should just draft a better contract?
Well, I'm not an insurance company. Well, let's not pretend that this was a meeting of the minds. Let's not pretend that anybody sat down and considered that this contract was intending to cover first-party benefits paid by the city of Detroit. It's a general indemnification clause, as a brother counsel has noted. They have many of these vendor contracts. All these self-insureds are, because they have the resources, they're in the position to say, this is the contract. If you deal with an entity, Ford is one of the self-insured entities, their terms and contract conditions are on their website. You don't even see them necessarily, but they're going to be heavily handedly applied, and there is not going to be any negotiation. Even if you could, I would think that if the legislature wanted to allow for indemnification on a fault-based contractual basis, they would provide rules to govern this. So it's not just the computer vendor who happens to be driving down to check on the server in the city of Detroit and is in an accident with a bus is suddenly liable for those damages. That's nobody, they didn't contemplate that. The contracts don't say the city of Detroit is self-insuring and you may be liable for those damages. This is all just falling under a general indemnification clause.
Okay, thank you. Any other questions for Mr. Caffrey? You have 53 seconds. Would you like to finish off with anything additional?
No, I'll let Mr. Ramey take over. Thank you, Your Honors.
Thank you very much. Mr. Ramey, you have some rebuttal time.
Thank you very much. The idea that this is going to increase no-fault litigation is completely, in my view, ridiculous. This is a case of first impression. The city at any given time is probably handling 500 no-fault cases that I have the joy of overseeing. And the fact that there's one case like this over my 7 years here at the city, I think makes the point. But even, every time you have a contractual indemnity, you're going to have potential litigation until the contract is construed. So once this contract is construed and once this indemnity clause is construed, there shouldn't be any further litigation about it. And the fact is, this litigation arose after the city had paid tens of thousands of dollars voluntarily in no-fault benefits. The reason this litigation was filed is because there was a dispute as to Mr. Bronner's continued eligibility for no-fault benefits. That's a story that happens daily in the city of Detroit. So to say that the indemnity issue is going to increase litigation really has no basis whatsoever in reality. And as far as the case that was filed, these cases take time to resolve because typically each side wants to get a medical exam and there are medical records. So there's no evidence in the record that the indemnity issue prolonged the underlying litigation. And what happened there is the trial court did exactly what this court has directed. The trial court took briefing on the contract and determined properly that the city had made an argument that GFL was the primary insurer. That was a bad argument, should never have been made. We've expressly disavowed it. But the trial court correctly ruled that we were entitled to contractual indemnity. And that's exactly what this court has directed. So there's no evidence whatsoever from anywhere that this is going to increase litigation or in any way interfere with the operation of the No Fault Act. Chief Justice McCormick, you were absolutely right about the issue of this parade of horribles that insurers are going to start suing their own insureds for contractual indemnity. The whole business model of commercial insurance is that the insurer conducts actuarial studies and determines the potential risks and charges premiums. And the insureds pay those premiums precisely because they expect the insurance company to pay the losses. That is a different business model than what is at issue here with the city of Detroit, where we're simply trying to protect our taxpayers from the negligence of vendors. And GFL, by the way, is one of the world's largest garbage collection companies. The contracted issue is $50 million. And to suggest that this was not fairly negotiated is really quite a bizarre position. So this, GFL obviously is not concerned about the sanctity of the No-Fault Act. They're concerned about trying to avoid their contractual responsibility to pay the city for damages caused by GFL's negligence. And there is no basis in the No-Fault Act for that position. There's no basis in this court's decisions for that position. And we ask the court to grant leave and reverse the Court of Appeals and reinstate the very sound opinion of the trial court. Thank you.
Thank you, Mr. Ramey. Let me see if anybody has any additional questions for you. Are there any additional questions for Mr. Ramey? Okay, seeing none, thank you both for your presentations. The case will be submitted. That concludes the January case call. Thank you all.